Welcome to The Ethical Patent Lawyer. To send a question to the presenter, type in the box below the Participation tab. Program materials can be found under your Supplements tab. We also encourage all our listeners to complete a survey of this program. The link can be found under your viewer window. It is now my great pleasure to introduce our presenter for this program, Emil J. Ali of McCabe Ali LLP. Emil, I'll turn the floor over to you for further introductions.
Thank you so very much. It's great to be here with everyone, and I am looking forward to discussing with you a primer on the ethics and regulation of patent prosecutors. We'll talk a little bit about trademark lawyers as well, but mostly this CLE is focused on patent prosecutors. So, folks that are registered to practice in patent matters before the USPTO. A lot of these rules are also applicable, obviously, to patent agents and those granted limited recognition. My background, I'm an attorney. I'm actually a registered patent attorney as well, but I focus my practice on the intersection of IP and ethics. So I'm an ethics lawyer with an IP background. As far as I know, I'm one of two in the country. The other one is my partner. And today I'm going to be going over a few major points that I think are really relevant to a mid-career patent prosecutor's understanding of the ethics roles. So obviously, while this is great for somebody that's at the beginning of their career, and of course, great for somebody with lots of experience, I think ideally I like to keep it right in that middle, that sweet spot, because you already have a lot of knowledge. I'm not going to be going too much into the basics, but I'm going to try to introduce things that you may not fully be aware of at this point. Then from there, what we'll do is we'll try to go through some nuances about things like competence, reasonable inquiry, right? That's become really important these days. We'll talk about mistakes because we all make mistakes and how to address those mistakes. And then we'll talk about those dreaded IP conflicts of interest, right? IP conflicts are extremely similar, yet very different to traditional conflicts of interest. And it's really helpful to understand subject matter conflicts and also the Rule 1.8 or 37 CFR 11.108 conflicts dealing with taking an ownership, for example, in a patent or patent application. Then we'll talk about the supervision issues. So when you work in a law firm or even non-law firm, if you're an in-house team, how to deal with the supervision of other lawyers and non-lawyers. And of course, questions. On the screen next to me, I actually have a website open, which is going to list out all the questions that you send in. So I encourage you take this time to ask me any questions. You'll have access to, I believe, this recording, but you'll also have access to the slides and material. So take this opportunity to interact and ask any questions you might have. So with that, let's talk very briefly about practice before the USPTO. And I don't expect you all to memorize this, but I expect you to think about using this potentially as a reference. Why? Because traditionally, the practice of law is regulated by states, but patent law is regulated not only by the USPTO, but also by states. But traditionally, the practice of law is a state-by-state issue where it matters a little bit about what law you're practicing, but also where you're practicing that law from. So we call that a butt-in-seat requirement. Well, the USPTO doesn't have that, right? Because it doesn't matter where you're practicing from. I'm licensed in multiple jurisdictions. Physically, I'm in California right now. Does that mean that the USPTO does not have jurisdiction with me because they're headquartered in Virginia? No. If I'm practicing patent law from New York, they still have jurisdiction. Let's say I go to Mexico and I'm practicing before the USPTO. They still have jurisdiction over me because it's based on the subject matter of the representation. And 11.5 is very, very interesting because this is only 11.5B. There's other parts of it. There's B1 and B2. It says practice before the office includes, but is not limited to, basically anything that comprehends any matter connected to the presentation of anything before the USPTO. So that's really, really important for you to be aware of. So giving advice in contemplation of filing a patent application, right? So not actually appearing before the USPTO. That is practice before the office, according to the USPTO. So how does this all interplay? Well, as I mentioned to you, the USPTO has jurisdiction, right? We're not talking about the Commissioner of Patents. We're talking about the USPTO's Office of Enrollment and Discipline. And the statute 35 USC 2 talks about how the USPTO can establish regulations that govern the recognition of folks that practice before the USPTO. And they've done that. It's 37 CFR Part 11. So there's some cases up here. I'm not really going to explain them too much, but what I will say is Sperry is a very, very important case that talks about how federal patent law or patent regulations and statute do sometimes preempt state law, but only to the limited extent necessary to achieve federal objectives. So what does this all mean? Well, there is no express preemption, right? What there is concurrent regulation, but if state law contradicts federal law, then federal law will control. And that's what Kroll v. Finnerty says here. Kroll v. Finnerty says, hey, it's not that New York can't prosecute you just because it has to do with patent law. New York can do whatever they want as long as it's not contradicting what the USPTO allows you to do. So why is this important? Because as mentioned in Kroll v. Finnerty, we learned that it's not only the USPTO rules apply. Usually it's the inverse. A lot of people say, well, USPTO cannot discipline me because, when I got in trouble for robbing a bank or got a DUI, has nothing to do with the practice of law. Or let's say that I had a family law matter. And in the family law matter in the state of New Mexico, I failed to appear in court. I got sanctioned, and I'm under investigation by the New Mexico bar. Well, the USPTO can discipline you for that as well. And ABA Model Rule 8.5, which is not actually adopted by the USPTO, is still very persuasive to them. They look at that and say, well, we look at the choice of law, what rules apply, but at the same time, we have disciplinary authority over you for essentially eternity. Doesn't matter if you have resigned, et cetera, we still maintain disciplinary authority over you for conduct within or without the practice of law before the USPTO. So enough about the background about the rules. I know that was a little bit boring. Let's get into the meat of what we're here to talk about. So my first point was to talk about competence, right? Here, I'm required under the various CLE requirements to list out some of the ethics rules and keep them in there. So for our purposes, I want to just say that 37 CFR 11.101 is the competence rule, and it's based upon the model rule and probably looks almost exactly like most state rules, save for the fact that instead of the word practitioner, most of the state rules will say a lawyer. So you're required as a registered practitioner to provide competent representation. So, what are those factors that you look at? Well, you don't have to be an expert. You don't need a PhD in a specific skill set. You don't need to have any sort of specialized training per se. You should have a reasonable amount of competence, and that competence can be gathered through some element of training, preparation, and study. So, for example, that preparation and study could be done after you take on the representation. But let's ask some very pointed questions. Can a patent practitioner with a chemical background prosecute a mechanical application? So let's break that down. You have a PhD in, let's say, chemistry. You've worked for 20 years in-house at a oil company. Let's say you worked at Chevron or whatever. So you work at this company, and all of a sudden you decide, I want to go out on my own. I want to, help independent inventors. You have no concept of mechanical applications or mechanical inventions. Let's say that for a second. But you know how to prosecute a patent application. Would it be appropriate for you to prosecute a mechanical application for an independent inventor? So putting aside, are you prepared to, be able to track your time, to send out an engagement letter, et cetera? There's no rule that says you are stuck only filing chemical applications for the rest of your life, but you must be competent in the work that you do. And there's a somewhat of a subjective standard, right? There's no objective standard saying you are competent today, you're not competent tomorrow, or vice versa. So in this particular instance, what I like to know is, are you comfortable in understanding how something works? And it's not to say that you're going to be billing your client to learn how to do something that they expect you to know, right? That's really, really important. Under the same vein, is a patent lawyer eligible to file a trademark? Well, first of all, if they're just a patent practitioner, right, a patent agent is not eligible to file a trademark. But a patent lawyer, well, a trademark can be filed by obviously somebody with the authority to bind an application. So technically, an applicant could be pro se. But if you, as a practitioner, are doing it on behalf of another, and you are a licensed attorney, the standard is under the Administrative Procedure Act. You just need to be an attorney licensed in a state or territory and in good standing. But let's go back to, are you competent to file a trademark? So a lot of people will say, well, if you can file a patent application, you can file a trademark. I get it. I'm sure you could probably file a trademark application form through the online filing system, right? You're probably going to be able to complete that very easily. I'm sure you can watch a YouTube video. But the question is, can you prosecute that trademark application? Can you explain to the client in advance of filing the application whether or not to get a search? The difference between a 1A and a 1B application. That's your job as a lawyer, right? How do you separate yourself from an online filing company? Because you provide that bespoke advice. So the answer is yes, a patent practitioner can file a trademark. Again, it is subjective. With enough study, a patent lawyer can become competent to file trademarks. Can a trademark lawyer file a patent application? No, because you need a special license to file a patent application. So speaking of 11.5, I talked to you about practice before the office, right? And practice before the office in patent matters includes, giving advice in contemplation of filing a patent application, which requires USPTO registration. So this is a tricky question. What can a trademark practitioner say about patent protection? This is a very, very unique one because I've seen the USPTO go many different ways on this. I think it really depends on the facts and circumstances, but trademark practitioners need to be wary not to advise somebody, hey, you should seek utility protection. You should seek design protection. This is how it will work for you. The best thing to do would be to take that and refer it to another practitioner. So that last point I have, I listened to Emil J, and I figured I could, with enough study, become, properly acquainted with filing a trademark, but I'm stuck. What do I do? How do I become competent? Well, again, continue to study, associate with another trademark attorney, right? A lot of times that requires client consent because it's confidential information being shared, but sometimes just talking to a friend. I think it's really helpful to have a network of other practitioners to rely upon, sometimes to refer things out to them, but sometimes to ask them, say, hey, I don't know what to do here. Sometimes there's listservs, but be careful to follow the ethics rules. Be careful not to share confidential information with third parties. So dovetailing off of competence is the reasonable inquiry. So this is a very, very interesting dilemma that I feel a lot of clients get into. So if I were to cite the first rule, Rule 56, everyone is going to say, yeah, materiality, we know that. You have to have an intent to deceive, thereseins. I'm not going to discuss Rule 56 too much here, right? Here, I want to focus on 11.18 and 11.303. 42.11 is for PTAB proceedings, but I want to talk about 11.18. So for those people that litigate, and I assume most of you are probably prosecutors since this is a prosecution-focused CLE, but the folks that have litigation experience, or at least remember from law school, the federal rules of civil procedure, remember that there's something called Rule 11, that when you sign or certify something or file or later advocate on behalf of that paper, you're doing so after information and belief with an inquiry that's reasonable under the circumstances. But did you know that as a patent prosecutor, trademark attorney, etc., that you're doing the same thing with every document you file with the USPTO? So whether it's a set of claims, whether it's an IDS, an ADS, a microentity certification, whether or not you sign it or just file it, you're signifying to the USPTO that you've done so on information and belief after an inquiry that's reasonable under the circumstances. Again, very subjective. But it is really important to make sure that you pay attention to what you say and how it might be perceived. And this dovetails with 11.303, which is very similar to the ABA model rules, Rule 3.3, which basically says you're not supposed to provide false information or testimony to the USPTO or any other tribunal. So I talked about 156, but first I introduced some of these other issues. Well, I'm going to briefly talk about your Rule 56 obligation because, as we know, it's not just the inventor that has an obligation, it's also the attorney, so you, who prepares or prosecutes the application. Unlike the conflicts rules, which are imputed to others, there has not been a single case that outlines that Rule 56 is imputed to everyone in the firm. It's really about the knowledge that the human being has, right? So the other issue is every other person who's substantially involved in the preparation and prosecution of the application and who's associated with the inventor, applicant, etc. So that becomes the CEO of a company or anyone that might have otherwise been involved in the application. Those are people that you should be very mindful of. So I want to go back to Rule 303, right? So 303 sets forth the duty to disclose legal authority in the controlling jurisdiction known to the practitioner to be directly adverse. Well, that's less important in an inter partes proceeding. It's more important here because most patent prosecution is ex parte, right? Ex parte means you have an affirmative duty, right? That's what Rule 56 is all about. There is no opposing counsel. The patent examiner is not the opposing counsel or opposing party. They are the adjudicator. They sit like a judge. So you have a duty to be transparent with them. And that's why sometimes those decorum rules come into play as well. So it also talks again about Rule 56 within Rule 303. So Rule 56 would be considered more of a substantive rule. It creates a burden on you and burden on the client, but Rule 11.303E specifically brings that into the ethics rules. It says you have a duty to disclose information necessary to comply with the duty of disclosure provisions, i.e. Rule 156, Rule 1.555, etc. So the ABA model rules do not discuss this provision. So for example, if you are a member of the New York Bar, the New York version of Rule 3.3 does not have this because they didn't contemplate the USPTO's unique set of rules when it comes to duty of disclosure. So I want to talk very quickly about the lessons that you need to know about from reasonable inquiry. So a reasonable inquiry is very, very subjective, right? I like to say if it's not in writing, it didn't happen. So when you receive a document from the client, what steps have you taken to verify the accuracy? And I'm going to give you two diametrically opposed spectrums. So you're dealing with an independent inventor, unsophisticated client, never used a lawyer, never filed a patent application. The level and type of explanation and the amount of time you're going to spend is going to be different than working with Google and working with their in-house counsel, their in-house IP team, that they have filed 50 applications with you and your firm over the past year, that they know what they're talking about. They know their disclosure obligations. They know the risks. They may not always follow it, but I think the burden is going to be a little different on you, right? So reasonable is going to be different with two different categories, and depending on what's being stated, right? So I'll talk kind of briefly later about things like signatures, right? You want to make sure the client is actually signing the document. You want to make sure the client is in fact doing things appropriately. So let me skip over GS Cleantech for a second. Client tells you that they were the sole inventor. Do you investigate? Well, sometimes, yes. I mean, I think it's helpful to have a conversation. So with that independent inventor, you probably want to have a conversation with them. But let's do the inverse. Let's say you talk to two joint inventors. They're both your client. There's no separate applicant. The applicant is basically the two joint inventors. Entitlement to the whole. And one seems to be the owner of the company, and one seems to be the person that's really the one developing that disclosure and the invention. Is it possible that the owner of the company simply calls themselves a joint inventor because they think that creates ownership? Right? That could be a problem. It could be also a conflict for you because you're telling somebody, hey, you're not really my client. I don't know exactly what the relationship is, but that's why it's important to develop these things, maybe have standard operating procedures. But the inquiry here would be to do a claim by claim analysis, right? Inventorship is a very, very objective test. I mean, there are some level of subjectivity here, but you need to establish, reduce something to writing that says, you know, person A, inventor A, gave rise to claim one. Claim two was from inventor B, or A and B, so on and so forth. Especially when you have multiple inventors, it's very important. Because the worst thing that can happen is somebody calls themselves a sole inventor and you have nothing in writing asking the client to basically explain if there was anyone else involved in the process. Same thing with microentity, right? Client tells you they're a microentity. Well, you file 20 applications for them. They're probably not a microentity. That is objectively not going to be a true statement. But let's say this is their first filing. Well, you have no understanding of their financial situation, but having a conversation with them and maybe reducing it to writing, maybe asking their tax returns might be helpful. Well, a lot of you will say, well, that wastes an hour of my time when it's just easier for them to file under small entity. Unfortunately, sometimes with the way the aggressive tack that the USPTO has taken against microentity status, that may be the most appropriate way to go. So let me step back and go to GS Cleantech v. Adkins Energy. I think this is a case that all patent prosecutors need to see. It was not granted cert at the Supreme Court, but it's a really interesting case dealing with a law firm called Cantor Colburn, where they represented a patent applicant after the application had been signed. And to make a long story short, they were accused of inequitable conduct by virtue of not asking the right questions, right? They didn't ask questions about an on-sale bar. And so this is really important, right? It really develops very well into this reasonable inquiry standard. So not only do you have an ethical duty, but also under your inequitable conduct / duty of disclosure standard, the lawyers are being held to this high level saying, you have a duty to ask the right questions. If you put your head in the sand, not only can you get reamed in the court, but your client can lose their patent protection. So very, very important lesson. I encourage you all, if possible, to read that case. So I want to go through a quick hypothetical with you. So a client asks a patent practitioner to file a patent, to file patent applications, multiple patent applications. The client claims that they're eligible for microentity status, whether it's because you ask them, hey, which one do you qualify for, or because they went online and figured it out themselves. But they said, I'm eligible for microentity status. Are you supposed to take any additional steps to make sure that that's okay? And if so, what are those steps, right? Or can you just sign the certification or say, hey, client, if they're a non-juristic entity, client, why don't you sign it? Well, this is a really, really important question because there's been a few disciplinary actions on that point. One of them is In Re Chu. So in this case, respondent seemed to be a solo patent agent and was not represented by counsel in the investigation with OED. So OED basically said, by not reviewing carefully the eligibility for microentity status, that this person violated the Rule 11 from the USPTO rules, which is 37 CFR 1118B, and by making a false statement to the USPTO. Again, so by not reviewing the information that your client presents to you, by just taking them at their word, you're doing something wrong. Not saying I agree with it, but this is the perspective currently out of the higher ups at the USPTO and the OED, right? They're saying you need to basically treat your client like they're not telling the truth. Ask them to prove everything. And I know this is a very difficult thing to go through. Obviously, this person was dealing with Chinese applicants, and that is something that the USPTO has been really harping on lately, but it is something that I encourage everyone to be mindful of. So he was publicly reprimanded for specifically signing 171 microentity certifications over a period of time, without being able to prove, essentially, that he had done any inquiry. And he said he didn't know to ask clients about other applications because there's a limitation of how many applicants you should have, and of course the income requirement. And he didn't have a docketing system to track it. Again, I assume this Mr. Chu was receiving referrals from another company, and there are other issues at play, but it was a very interesting lesson that when I look at it and talk to my clients, they say, hey, a lot of us aren't doing this. I mean, there's big firms out there that are not doing this, but it is something that if you come under the purview of the USPTO or get on their radar, it's something that you have to be mindful of. So let's talk about mistakes. I think we all make mistakes. I, of all people, am not infallible, right? I'll make occasional spelling errors, etc. We all make mistakes. Some are minor. Obviously, unfortunately, some could be major. And I think that's why we have a second set of eyes that reviews certain documents. That's why we have malpractice insurance. Okay, so let's go through a quick hypothetical. You make a mistake in a matter, but don't realize until after it's complete. So let's give an example. You file a patent application, but then you realize that you forgot to add in a claim. Well, on the surface, it looks everything's fine, but if the client goes to enforce the matter, it could backfire. Well, let's actually say the patent has already been granted. Well, the client's happy and continues to provide you with new work. Do you have a duty to tell that client? Right? That's really, really important. Luckily, we have an ethics opinion for that. So this is an ABA opinion. It's formal opinion 481 from 2018. So there's two parts of this. One, we have to decide, is there a current or former attorney-client relationship? Because that's very important. So let's start with the former. If you have an error that relates to a former client, you do not have an obligation to inform the former client. And a lot of people are like, well, why? Well, it's saying you don't have an obligation. Doesn't mean you cannot do so. And I think the way I interpret it is they're a former client. Think of how former clients are for conflicts purposes. You don't owe that same fiduciary duty. You owe a different type of duty to them. But also, what if they're more willing to sue you? What if they're represented by somebody else? What if you're now adverse to them in an unrelated matter? Those are all important considerations. But if they're a current client, and if we go back one slide, the client is happy and continues to provide you with new work. They are a current client. So if it's a current client and you believe that you've materially erred, you need to notify them. Well, how do we know that you've materially erred? Well, the opinion says that one, it's either A, there's a reasonable likelihood of harm or prejudice to the client, or B, if the client figured it out, they would likely consider terminating you because they think you're incompetent or otherwise, right? Even without any harm or prejudice. I think that's very, very helpful to know because, again, it's always a good practice to try to own up to your mistakes, but it is something that I deal with all the time, right? A client will come to me and say, I made a mistake. I go through this opinion with them and I tell them, but then we talk about the soft issues, right? We say, is there a statute of limitations issue? If I bring it up, is it going to open up a can of worms? I can't tell the future, but I can help advise lawyers on what those best practices are. So what if the mistake was made in a court filing? Well, so if the mistake was made in a court filing, the ABA opinion talks about notification to the client. Unfortunately, if it happens in a court filing, you may have an obligation to the tribunal, and that's where Rule 3.3 applies. But let's skip that for a second. Let's go to the second question. What if the mistake happens in a patent or trademark application? And let's, instead of saying we forgot a claim, let's say that we made an error in, let's not pick something easy. A disclosure obligation would be easy, right? Because there's a separate rule for that. Let's say that you found out that your client is no longer, actually, no, here's a great one. Your client never actually signed the oath or deck. The inventor's oath was not signed by the client. It was actually signed by a joint inventor. The joint inventor thought that they could, sign the document. Well, according to the USPTO, that joint inventor signing the document has committed fraud on the USPTO, and by you submitting that document, you've committed fraud on the USPTO. I don't necessarily, again, agree with that, but that's the USPTO's perspective. They think that that's not actually a mistake, that it's a false statement, and it implicates 1118 and 11.303. The USPTO is going to say, hey, you need to take immediate corrective action to notify the tribunal, in this case, the examiner, the USPTO, somehow to let them know that you submitted essentially a false statement by virtue of this, false inventor's oath. So that's generally the situation that you're going to be in. You're going to try to use 11.303 and 11.18 and habilitate the statement that was made. So now to the juicy stuff, right? Conflicts of interest. And excuse me for these photos, my paralegal put them in. He thinks that my CLEs are pretty dry because they're mostly without images. So he chose some very unique and aggressive photographs. But I want to talk about conflicts. So first of all, this is a very, very basic slide because it's really the basics of conflicts of interest. I like to say, and I tell this to all my CLEs where I talk about conflicts, I also teach my law students this. Conflicts are everywhere. Clients will usually sign waivers, but a waiver requires informed consent. Okay, this is the tricky one. A waiver requires informed consent. It's not, oh, let's just have them sign our advance waiver that says forever and beyond, even after you're in your grave, you waive all conflicts. It's not how it works, right? And it's also not how it works where you can just avoid getting a waiver and not have any informed consent by virtue of doing things like having different teams. That just doesn't work. So these are kind of the three basic things I like to live by when it comes to conflicts, because you have to recognize that conflicts are everywhere. I like to say that no attorney that I know of has ever gotten disciplined for a conflict waiver that they didn't need. So, if you wanted to call me and say, hey, Emil, should we have a conflict waiver for XYZ? I'll say, I think you can get away with not doing it depending on the circumstances, but it doesn't hurt to have one. So why bother calling somebody like me and getting advice when the advice is pretty simple? You're not likely to get in trouble for having a proactive conflict waiver. Obviously, again, the clients don't always sign them, but generally speaking, it's all about how you posit or position the relationship and the waiver. So what constitutes a conflict? Well, I think it's really, really important to, and we'll talk about the specific rules in the next slide, but it's really helpful to understand that you need some sort of client relationship, right? You don't need two, just need one, right? Because you can have a self-interested conflict. Then you need a representation of another against that client, so one against the other, or the risk of being limited by anyone. So being limited by another client, former client, third party, maybe a payer, or your own self-motive interest. Does not require harm, right? Improper result, damages, harm, that's all not an ethics issue, that's a malpractice issue. We're here talking about ethics. Malpractice is related, right? If you generally comply with the ethics rules, you're hopefully helping yourself from getting a malpractice lawsuit. But one other thing about conflicts is the optics. Optics are not necessarily conflicts, but they can lead to interpretation of conflicts. So what does that mean? So some people, when I use this term optics, they're like, well, are you talking about political issues or political clout or client management? And the answer is yes, that's what I'm talking about. So when you're representing a client and their biggest competitor publishes a patent application, that's already something that you can expect you to get a call about. They're going to say, hey, can you help us with this application? We want to claim around it, or we want to work around it. But what happens when they see your name, their patent attorney, on the cover of that patent publication, right? That's why optics are important. You want to know that, hey, if my client's probably not going to appreciate me representing their biggest competitor, and I'll just say it is not, and I'll talk about this in another slide, it's not unethical for you to represent a competitor in the vacuum, right? Subject matter conflicts are another issue, but competition. You represent, Microsoft in, let's just say Microsoft Windows and Mac OS are competitors, right? It's not like you can't represent Mac OS, right? They're just economic competitors, right? Apple, Samsung. As long as you're not, helping each other kind of work around the other, it's okay generally. It may give you some limitations, but in the grand scheme of things, purely economic competition is not going to be a reason for disqualification or for some sort of ethical dilemma. But as I mentioned, I have to go through some of the ethics rules. So bear with me for a moment while I just explain just where to look for the ethics rules. So when you're dealing with a current client relationship or a business transaction with a client, you're going to look at rule 11.107 and 11.108. So for example, you want to take an interest in a patent application as part of your fee. You want to get shares from your client. You're going to look at rule 11.108. You have two clients that are suing each other and you need to know if you can accept that and how to do it. You're going to look at 107. If you have a former client relationship and you want to know about things like, can I take on this representation? Same or substantially related matter. You're going to go to 11.109. You're going to see, hey, well, we had this former conflict based upon this attorney that's no longer with the firm. Is that still a problem? Well, we can look at the imputation rule under 11.110. And for those that are coming and going with the revolving door of government, becoming a patent examiner, joining the USPTO, et cetera, you're going to look at 11.111. This is very interesting because unlike the regular conflict rules, the USPTO and the ABA understood that just because you represented the government doesn't mean you represented the entire government. You represented one small organization, and the rules are really applicable based upon what you represented them for, that specific subject matter. It's not for all an attorney that you're prohibited from being adverse to the government. So let's talk about subject matter conflicts. So first, I think I've hopefully helped explain the traditional conflicts, but I want to talk about subject matter conflicts. So the best way for me to help explain a subject matter conflict is, if two people walked into your office on 2 different days in the same week and both said, I want to file an application for a perpetual motion machine that uses water to create electricity. Obviously, forget my jest about the perpetual motion machine, but some sort of apparatus for harnessing energy from water, right? You might say, I need to do a patent search, all that stuff. But is that a subject matter conflict? Well, not 100%, but I'd say it's probably 99% there. 2 people come to you the same week. That's already a little bit of a problem. You might want to talk about inventorship a little bit because maybe they actually work together, but you shouldn't be sharing that information. But they come to you, you're going to want to analyze whether or not you can take on one or the other or both. And the best way to do that is to outline that subject matter. And this is why, it's really hard for, conflicts folks within a firm. Most conflicts attorneys or in-house general counsels or ethics counsels don't understand the subject matter of conflicts of interest. And that's why they end up having problems, right? It's a really, really big dilemma that people have at law firms is their conflict checking systems are not designed for the specificities of subject matter of representation when it comes to patent law, especially Rule 56, et cetera. So dovetailing to that, are we in a zero-sum game? Is it that if we helped client A with their apparatus for using water to harness electricity, would that prevent client B from getting their patent? Not necessarily, but it is important to understand, are they the same or very similar invention? So the easiest way for me to understand, is there a high likelihood that one application will be cited against the other? That's usually my rule, is I say, well, one, is it likely that if the same lawyer was representing both applicants, would they think they're required under Rule 56 to file an IDS, right? To say, hey, there's this other application. Would the office action cite the other application? I think those are really, really important questions. Economic competition, not that big of a deal. I mean, it's helpful to know for the optics, but similar or same invention. Again, somebody can make an argument either way, but I think citing the other application is the better one, right? And a lot of people over disclose when it comes to IDS. So if you're that type of person, is it likely that you would disclose that? Well, you could still get a conflict waiver, right? A client may still want to sign a conflict waiver. Obviously, in this case, both clients would need to sign that conflict waiver. So let's give an example on the display industry. So if you represent, let's say, LG and Samsung, both in patent matters, is that allowed, right? Objectively, they both file applications and work in the display industry. They both have TVs and monitors, right? No, it's not a big deal. Why? Because comment 6 says that if they're just economic competitors, it shouldn't be a problem. But are they seeking coverage for the same devices or technology, or are they likely to be cited as art against each other? And here's where you need to kind of put your thinking hat on. So you're filing an application for Samsung in the field of televisions. And let's say you're doing some sort of a chip for them for their new, I don't know much about TVs, but new OLED technology that's at 120 hertz. But then with LG, you help them in computer displays. When I say you, who cares if it's you, your firm, whatever, right? You're one firm. It's all imputed under Rule 11.110. Well, isn't it likely that a display on a TV is very much related to a display computer monitor? Well, if so, it's very likely that those would be considered the same technology area, right? You can say same art unit, same general area. It would be somewhere you'd really want to be extremely careful with, right? That's one area where I want you to be very careful in dealing with subject matter conflicts. So how do I give a practical takeaway here? Well, I say it's usually pretty easy to see a subject matter conflict. A lot of people disagree, okay? If I'm defending you in an inequitable conduct case or an ethics case, I may disagree with my own statement here, but generally speaking, it's easy to see because you can tell they're in a similar technology area, right? Why not get a proactive conflict waiver? Avoid having an ethics issue in the first place. Try to get that proactive conflict waiver. So the question is, have any courts spoken on the issue? So yes, there have been a couple courts. I think the most notorious one of recent time was back in I think it was 2014, if I'm not mistaken, and that's the Finnegan Henderson case, right? Finnegan Henderson, big patent law firm. Unfortunately, they didn't have a system that could check for conflicts in an appropriate manner, right? So what did the Supreme Judicial Court in Massachusetts say? By the way, it's a state Supreme Court case. It was basically like a malpractice case. The court there said law firms run significant risks, financial and reputational, if they do not avail themselves of a robust conflict checking system adequate to the nature of their practice. But they did also say that Rule 1.7 issue does not standing alone constitute a actionable conflict of interest issue, right? Subject matter conflicts don't automatically violate Rule 1.7. So I want to talk about a couple other areas just very briefly that I think would be helpful for you to review. I know we're running out of time. We just got about, I think, 18, 17 more minutes. So we talked about that office action conflict. It's actually very well addressed in a search issue in Virginia Legal Ethics Opinion 1774. Essentially, in that legal ethics opinion, the committee of volunteer members of the bar was asked by an associate. The associate said, "Hey, I was, doing a patent search or invalidity opinion about, and I came across another client's patent, and I had to write about it. And when I approached my supervisor, the supervisor said, "Oh yeah, it's not a conflict, and because if we stop writing the opinion now, our client's going to be left in a lurch." And the committee said, "Nope, that's a conflict of interest. You should not be completing that opinion, right? That creates a problem because you have a conflict. You could have gotten a waiver, like they didn't really get into that, but technically you could have gotten a waiver, especially if different people were working on the different matters. But in this case, it was a conflict of interest." Another case, Andrew Court v. Beverly Manufacturing. I believe that was a case out of the District of Illinois, and I think it's the Northern District too. And this had to do with a law firm called Barnes Thornburg. To make a long story short, there were opinion letters drafted by counsel to show a lack of willfulness. And those had to be excluded, and the client basically got injured because the law firm had ended up being on like both sides of the equation because of a bunch of mergers and acquisitions by Barnes and Thornburg. So you really have to be careful, not only with client conflicts, but also conflicts from other attorneys joining your firm. So again, Rule 11.110, the imputation of conflicts of interest. So what are some questions that we can ask when dealing with office actions? So let's say that one of your client's applications was cited in another client's office action. So here are the questions that I would like to ask. Did you identify the issue in advance? Right? Hopefully you did, but if you did, you probably would have gotten a conflict waiver. But let's say you didn't, right? Should you have identified it? That it's probably a better way to phrase the question, because then it goes to this is something that we should have probably addressed earlier. But let's say it wasn't something you should have identified. So let's go with, how do we deal with it today? First, what rule applies? Is it 11.107 because it's a current client, or 11.109 because it's a former client? Then second, how do we address the client? How do we address this issue? Are we going to say, hey, this patent is inopposite, right? Doesn't cover the same claims, and by doing so, are you limiting one or both clients? Are you pulling punches from one client in favor of another, right? That's very important to see if it's even possible to ethically represent these folks. Or maybe you have to pass it on to at least somebody else within your firm that's not you. That doesn't address the conflict, but it may help alleviate any concerns. But also, here's a good one. Is it clearly erroneous? And what I mean by that, is it like, did the client just did the examiner just cite the wrong application number and get lucky and find another application that your firm happens to be representing? I mean, is it just totally off base? And then, of course, can you get consent? And this is maybe something that you'd ask the relationship partners. So, is it likely that the client will understand this and agree to it? Or, hey, there's outside counsel guidelines, they're never going to agree to it. But when we're talking about consent, right, I happen to use the word assent here. That's just because I didn't want to use the word consent like 5 times in a row. But really what I mean here is your client consenting to a conflict waiver is more than just, oh yeah, sure, sign on the dotted line. You want to make sure that they understand and it's appropriate. So how can it be addressed is related to this. Can you ethically still represent both sides of this equation in an appropriate manner? And again, unfortunately, the discussion behind that and how to address it is going to be different if you're at a large firm where you have other people that can help you versus when you're a solo practitioner. It's going to be a little bit different, right? There's multiple people because sometimes it's easier to show the client, hey, we're not going to be the same person dealing with both matters. It can be 2 different people, 2 different offices that are going to be working on it. So a lot of people say, well, Emil, I work in-house or government. I'm never going to have a conflict of interest. Well, believe me, I have had many cases involving in-house conflicts, but a very interesting one is a publicly disclosed one is Dynamic 3D Geosolutions versus Schlumberger. And essentially, Charlotte Rutherford was an IP counsel at Schlumberger for 7 years. She had gone up the ranks in those 7 years. Then she left and went to go work for an Acacia company, basically an NPE called Dynamic 3D Geosolutions. And while she was at Schlumberger, her work involved a project that evaluated the patentable aspects of Petrel, which is an oil well mapping software, obviously for Schlumberger. And there she assessed the risk of lawsuits against it. And that work included looking at the 319 patent. That was the subject of this case. Well, she went and left and started working at Dynamic 3D Geosolutions, where she was involved in the decision to bring a lawsuit against Schlumberger. And she ended up hiring a law firm specifically on the same subject matter, on the 319 application that was acquired. So Was this a problem? Well, unfortunately, yes. This became a problem because she was involved in essentially the same or really substantially related matter dealing with her prior representation. So, what did the court say? They granted a motion to disqualify not only Schlumberger, but also the in house department, so all her colleagues, and the outside counsel. The court ultimately dismissed it without prejudice. And that's always a question I get. Why without prejudice? Well, it's a good question because disqualification, it could have been resolved with new counsel. So what the judge said here was Rutherford's company, Dynamic 3D, should not benefit from trying a case through the fruits of her unethical labor. But they said, hey, it's probably okay if you do it through someone else. So what do I learn from this? Well, I think it's appropriate for you to say, well, in-house lawyers are not immune to conflicts because you could have a conflict from something as simple as, hey, working on the same matter, but also if you're dealing with a licensing issue, if your company is licensing something from a client you used to represent, you might have behind the eight ball issues. So it's important to understand how the imputation rule works as well for in-house teams. If you look at the definition section, which is 37 CFR 11.1 or ABA Model Rule 1.0, it says that lawyers and in a partnership or professional corporation, et cetera, are all really considered to be one firm. But also lawyers employed in a legal services organization or the legal department of a corporation or other organization. So an in-house team is considered a law firm for imputation of conflicts purposes. All right. So a really interesting question I often get is, okay, well, you told me Rule 1.11.107 applies to current clients, 11.109 applies to former clients. I like 11.109. How can I make a less productive client an 11.109 former client? Well, there's a word that's used. It's called hot potato. And this case here from the District of Utah back in 2008 was the first one I could find, but it's been around for a long time, where basically the court said a lawyer or firm may not drop a current client like a hot potato in order to turn the client to a former client as a means of curing the simultaneous representation of adverse interests. So just don't play games, right? That's the really important lesson here. So let's talk about supervision. I will tell you that sometimes our non-lawyer assistants, paralegals, legal assistants, docketing clerks, are our eyes, our ears. They are some people that can help us, right? I'm on, CLEs all day today. Oh, and of course, and my phone just rings. So I'm relying on my paralegal to pick up my phone call, right? That's an important responsibility. But how do we make sure that they're doing things appropriately? Well, we want to make sure that as managers of a law firm, that we have reasonable procedures in place to make sure that lawyers and non-lawyers are doing things appropriately. So Rule 11.501 really is the supervision of lawyers, but 503 is the supervision of non-lawyers. And, if we look at the old school way of doing things, a lot of lawyers would really delegate a lot of work to their non-practitioners. And, in some cases that works, but I think the USPTO has been really very, very adamant that things like signatures really have to be done by the practitioner. So you're signing the final patent application has to be done by you. Signing a power of attorney, if you're allowed to do it versus the client, has to be done by you. Those are all really important things, but also making sure that you're supervising what your paralegal or non-lawyer assistant says to people, right? So if somebody calls and says, hey, can I talk to Emil? And they say, hey, Emil's giving a CLE right now for Thomson Reuters, but what's your question? My paralegal should not be answering a substantive question. It should be, hey, I can check with Emil and have him call you back, or I'll check with Emil and I will call you back, but they should not be providing legal advice. That's Rule 5.5 as well, 11.505. You should not engage in UPL in violation of the legal profession in that jurisdiction or assist another in doing so. So let's talk a little bit more about 501. So what's your responsibility as somebody in a partner level or management level, right? So as I mentioned, 503 requires you as a supervisor to engage in that sort of situation. But what about when you're dealing with lawyers? Well, again, you need to have reasonable efforts to ensure that you have, in effect, measures that all practitioners conform to the USPTO rules, right? You can't be everywhere all at once. But if you're running a law firm with more than a handful of people in it with a distributed workforce, especially post COVID-19, it's probably helpful to have a situation um, where you're dealing with employees that know the limits of what they're supposed to do. That you're making sure that cybersecurity is enforced, cybersecurity policies are enforced. You're making sure that attorneys are billing time properly, that non-lawyers are billing time properly, right? Those are all things that you can have in place. Well, how do you do that? Well, make sure there's procedures, make sure there's some auditing procedures in place to not only work with those rules, but also make sure that they're being followed. So again, define roles, monitor things. I'm not saying record all calls, but especially with non-lawyers, with your paralegals, talk to your clients, ask what's been saying, interview those, maybe listen in on calls, right? Maybe not do it surreptitiously. You don't want to scare people or make them feel inappropriate, but make sure that clients aren't getting wrong information. Make sure that people are talking clearly, right? Think of it even as a customer service issue. If your, legal assistant is answering a phone call saying, hello, that's probably not going to be very helpful for you. Maybe they should be answering it in a way that helps your brand, but at the same time, gives correct information and it does not engage in any activity that might be violative of the rules or engage in any sort of conduct that might be otherwise unethical or even criminal. So again, I want to go back to 11.5, which is one of the substantive rules I talked about that is really dealing with what practice before the office is. So I left out this part. Nothing in this section prescribes a practitioner from employing or retaining non-practitioner assistants, right? But those people have to be under the supervision of practitioners to assist the practitioner in matters pending or contemplated before the office. But there are a couple issues here. What does it mean to be under the supervision? Well, according to the trademark side of the office, so your patent contract doesn't say this, but the trademark side of the office is now saying that supervision means they really have to be employed by you. They can't be a third-party company. You can't even provide delegate access or sponsor a client's company under their version of the trademark verified account agreement. So something very important to consider. But again, many lawyers, I would say most registered practitioners, are probably working with non-lawyers in their office, and they play a very vital role, but we want to make sure that we're properly supervise them. So again, this is what I was talking about. The major points in this verified account agreement are no sharing accounts. So you should not be allowing a paralegal to use your credentials. If you do sponsor somebody, make sure that you're verifying those persons, you actually know who they are as human beings, and you're not supposed to sponsor anyone not affiliated with your firm. It's been interpreted a little bit differently about what that means, but generally speaking, we're going to make sure that you are not sponsoring people that are not employed by or retained by your law firm. So with that, I'm happy to answer any questions. I think a lot of people have questions about OED inquiries and how they work. I will tell you that we have a blog that has a lot of great information. I know it can be a very scary tactic, when you get involved in ethics dilemmas, disqualification motions, or have any other problems. I do encourage you to check out some of those resources. Our website and blog is www.ipethicslaw.com and McCabeandali.com. I'll go ahead and just put it on there. It's www.ipethicslaw.com. As always, I do encourage you to also feel free to reach out to me on LinkedIn and connect with me. I do post some information from time to time online and look forward to hearing from you, but I will keep it open just in case there are some more questions. All right. Looks like there are no questions. So again, thank you so very much for your time. If I have to leave you with just one small point, I would just say again, when you are dealing with clients, make sure you properly communicate with them, that you build up a rapport. So until you get to that rapport, make sure you ask the right questions. That's going to save you under 1118, hopefully under inequitable conduct. And one more thing would be, if it's not in writing, it didn't happen. Obviously, that's not a legal standard, but it's kind of the credo or the motto that I have, because if you get an inquiry or sued for malpractice, I need a document or some sort of evidence that says the attorney did this. And the only way to do that for me is with something in writing. I'm always happy to present you as a witness, but it's much easier when it's in writing. Even if it's a note to file, those can be very, very helpful. So with that, thank you so very much for your time, and feel free to reach out with any questions. Thank you.